into January now, and that's why I want to dive in and talk about some of the new labor and compliance laws to make sure your 2021 is on the right foot. Today, I'm really excited to introduce you to one of our partners, Michael Goldfarb. He's going to take us through some of the policy and law changes you may have missed. Michael's been an employee law attorney for over 27 years and has consulted with many different companies and different types and sizes. He's also conducted numerous trials related to employee law. Personally, Michael is really knowledgeable and a great attorney, so I think you guys are in for a great treat. If you have any questions, go ahead and type them in the chat, and we'll do our best to get as many of them answered as we can. And with that, take it away, Michael.
Okay, I'm just waiting for, there we go, I'm up and live. Good morning, everybody, welcome. Thanks, Scott, for the warm introduction, and we love being a great partner with CorpStrat. You guys are an amazing outfit. So, all right, we're gonna be covering the new laws that are important from an employment law perspective. As usual, in the Great Republic of California, we have quite a bit of information to get through, and I am going to be I'm going to place more emphasis, if you will, on some of the legislation and less on others, because it's just, some of it's pretty straightforward and some of it's just not, and I think deserves a little more meat on the bone, so to speak. Without further ado, let's jump to the first slide, or next slide. Great, thank you. So let's talk about, this is basically Assembly Bill, or AB 685, it's a pretty big deal. It's fairly involved. There's a lot of reporting requirements, and it also ties into something that I may mention several times, which is these Cal-OSHA emergency regs that were enacted essentially without a lot of fanfare and pretty much under the radar in December. And those new emergency Cal-OSHA regs are obviously, they all pertain to COVID in the workplace and are extremely cumbersome. So let's start with 685. All right. So 685, some of the reporting requirements are that when an employee contracts the virus, an employer must take action steps, including notifying affected employees within 1 business day of becoming aware of the potential exposure. The notice includes determining who was at the work site, including third parties, okay, during the infectious period. So again, this isn't just regarding your own staff. Well, what is the infectious period? So the infectious period, at a minimum, it doesn't have to be within this context, but at a minimum is the 48 hours before the individual in question developed symptoms. So part of what employers need to do is have effective lines of communications with employees, especially obviously those that get infected, because there's these lines of inquiry now, questions that employers have to go through in terms of an analysis in order to comply with these reporting requirements. So the employer has to determine who else could have been infected within, at a minimum, that 48 hours before that individual develops symptoms. So again, they're going to have to talk to that person. What is the work site? So the work site is, and obviously this is factual and it's going to depend on any given person's work site, but it's essentially limited to the same building or location where that individual was physically present. So in other words, the work site will not include areas, in a larger work site. It won't include areas that individual did not enter. Okay. So, again, that's another part of this analysis is you have to communicate with the employee, and then, you have to find out the nitty gritty about the nature of when and how this person thinks they got the virus, and when they first started having symptoms, where were they working, who else was located at that work site. Okay, written notice has to go to the potentially exposed other employees, any representatives that they may have. That's generally in a union situation where there might have representatives. And very importantly, okay, the employers of any third party or subs that you may have had working at those work sites during the infectious period. So again, this is why I'm emphasizing it isn't just your own people, it's third party employees as well. Okay, what does the potential, how does the potential, well, let's actually start with the notice. So what does the notice have to include? So you have to include the following: that one, they may have been exposed to the virus. Now, this is tricky. And the reason it's tricky is because you have to be careful what you disclose with respect to what the sort of conduit was, because obviously it's going to be a human being, right? And that individual has protected confidentiality rights when it comes to their medical conditions. So confidentiality kicks in when you're providing this written notice to whomever is required under this approach. So you have to inform people that, look, on this date, we think you may have been in the vicinity of someone who was infected, and therefore you need to take precautions, but don't disclose the identity. You have to tell the people whom you're providing notice what potential COVID benefits are available to them under the law. Now, under the FFCRA, those sick leave benefits ended as of the 31st of December. However, as some of you may know, the tax credit is extended until the end of March 31st this year. So that allows employers to voluntarily continue to offer that, 10 days basically of sick leave under the FFCRA if they want to, and then put in for a tax credit. But those are examples. There could be other types of benefits, internal benefits from the company, sick leave under state and local laws. So you need to look at what benefits are available. That has to be part of the notice. Also, anti-retaliation and anti-discrimination protections are included in this notice. You have to let people know that they will not be discriminated against nor retaliated by, putting in for potential leave, or letting their employer know that, I may have an issue here. Okay. And lastly, but not least, and this might even be the most important feature of this notice, is that the employer in question, where, the employer of whose work site we're talking about, that employer has to inform those people in this written notice about any disinfecting or disinfection and safety plan that they had in place. Now, AB 685 says that, your employer disinfection and safety plan should be in line with guidelines laid out by the CDC, the Federal Centers for Disease Control, and that's fine. I think that would suffice. But here's where I think we need to be very astute. I mentioned at the outset those emergency regs put out by Cal OSHA in December. Those regs specify the need for California-based employers to have a COVID protection plan. And it is a bear of a safety protocol. And I'm going to talk in a second a little bit about what has to be included in that type of a plan. But it's really important because, as you can see, it's tying into, well, what protections did this employer put in place? Okay. Now, as far as the notice goes, it can be in any written form that is reasonably calculated to communicate with these individuals. So if you traditionally use email, you can use email. There's no one size fits all, okay? Now, what can trigger this whole reporting mess? Because it is a mess, right? So one obviously is if an employee tests positive, that'll trigger it. If somebody, they don't have to necessarily be tested positive, but they can be diagnosed by a licensed medical professional as a COVID-19 victim, then that triggers it. If a public health agency has declared somebody to be suffering from COVID, then they qualify. And, lastly, if a county has determined that one of your employees died, and the cause of death was COVID, then that would be a trigger for these notices. So very important. Now let's talk about, really briefly, I'm going to touch on what a COVID protection plan, we're staying with this slide, but what a COVID protection plan would entail. Now this is very, very high overview, okay? Because we're talking about, I have an entire webinar dedicated just to this reg. So a COVID protection plan has to include a process for an employee to report exposure. It has to have a process for showing that you understand and have methods for accommodating those with pre-existing conditions, sometimes known as disabilities, right? Who might be dealing with COVID-19 or exposure to it. It has to contain information regarding testing, okay? In other words, why it may be required, what the reasoning is for that. A CPP, a COVID protection plan, also has to inform employees about COVID-19 hazards, okay? Which includes, individuals. Now, so it should talk about doing screening, okay, employee screening, medical screening, all right, how you go about that and what should it involve, how an employer responds to a COVID-19 case, how you trace anyone potentially involved in that infectious circle, okay? What are your what's the building's airflow? What is your workspace airflow? You have to show that the company is up on and reviewed public health orders, that the company has taken steps, if necessary, to improve the working environment, to make it safer, and that it schedules routine inspections. So that is just one section of the CPP that talks about hazards. It also the CPP also has to show how you respond as an employer to a COVID-19 case. You have to show that you verify and record testing, that you log the whereabouts of a positive tested employee who tested positive, where they were, that you trace their movements, that you have methods to notify other potentially infected individuals, and that you practice confidentiality in your notification process. So you can see how these emergency regs tie directly into AB 685, how the two go together, and violations can result in penalties. That's why we're covering these emergency regs. Okay. One of the really interesting things about the emergency regs that just came into effect is you have to offer testing at no cost. There are two sections in the regs that demand that. So employers must pay for that testing. We get that question a lot. Okay. You have to identify any workplace conditions that may be attributed to somebody obtaining the virus. Quickly, you have to correct hazards. You have to provide training, engineered controls, record keeping, and return to work out protocols. So that is how the COVID protection plan ties into the reporting requirements under AB 685. All right, let's move on to the next slide. So again, this is still part of 685. Now we're talking about requirements when there is a COVID breakout. Now I want to explain, there is 2 sections in this presentation. We talk about breakouts, one here and one later with workman's compensation. Those are different definitions for what a breakout is. So under this assembly bill, this new law, a COVID-19 breakout is when 3 or more employees who are not from the same household at the same work site test positive within a 14-day period. There you go. That is a COVID-19 breakout for purposes of AB 685. If that occurs, then that employer has 48 hours to notify a local health department of the breakout. What information has to be reported? That an employee tested positive or was diagnosed by a licensed healthcare provider or was ordered by a healthcare official to isolate or died as a result, one of those 4. Then for each notice, you have to include the worksite's NAICS number. And I'm not too familiar with those. I've come across them occasionally, but some of you might be. You got to look those up. There's a table that indicates that number. The name of the employee number, if applicable, the address of the business, the location, if different, of the particular work site in question. And then the employer has an ongoing responsibility to continue to notify local health departments of any further laboratory confirmed positive tests. So what that is really saying to employers is you need to create a protocol whereby if you've had a breakout, well, not even if you've had a breakout, basically you have to, because it's a 14-day period. So once an employee tests positive, that should trigger a new policy approach within a company that calendars those 14 days, and then everyone is aware, or at least whoever's in charge of collecting this kind of information. Okay, the clock's running, and if we get 2 more employees within that period, we need to analyze: are they in the same work site? Are they from are they related? Whatever. But what I'm getting at is that it triggers new processes that all of us as employers need to put into place. All right, let's go to the next slide. So continuing along, we're still in the same new law. Now we're talking about Cal-OSHA can declare an employer work site as an imminent hazard, and this can trigger penalties as a serious violation. So an imminent hazard is when Cal-OSHA declares an employer to be such, and it can shut either just the work site or it can shut the whole business. Again, it's really going to depend on the nature of what the work site is. That's a factual finding based on the circumstances. And then Cal-OSHA is going to put up it's like a poster, not a poster, but a posting basically saying, do not enter. You can't, this place is closed by reason of X, Y, and Z. So that's what's going to happen. And this could be a serious violation. And here's the rub. As you can see what this slide says, it can issue this serious violation without advance notice of any kind to the employer where an employee tests positive. That's a significant change from how Cal-OSHA normally does business. Because normally, and some of you may know this, when Cal-OSHA suspects a violation, right? Let's take a serious violation. They're going to give the employer sort of like a warning. Here's what we think we know exists at your workplace. You need to take mitigating action to reduce or to eliminate as much as possible this danger in the workplace, this health hazard. Okay, well, that doesn't exist here. That we're still on the other slide, by the way, and I think the slide just moved. But that isn't what's at play here. So Cal-OSHA comes right in and they hit you as an employer with a serious violation. All right. And immediately that employer has really one choice. to appeal and say, I'm not going to pay the penalty and I want to appeal the violation. So the employer must immediately calendar that appeal so it doesn't miss the time frame. And again, the CPP I just talked about, the COVID protection plan, ties in, because when an employer is going to want to contest or appeal that serious violation, it's going to need evidence to do so. Evidence that it had all these things in place, all these precautions, and a COVID protection plan is the linchpin. All right, next slide, please. Okay, these are the big ones, really, and that's why we're spending a little bit of time here. So, a COVID-19 presumption of workers' compensation. This is Senate Bill 1159 that really codified what Governor Newsom had passed earlier, I think around September of 2020, as an executive order. It's not exact replica of that, but it's essentially the main elements of that executive order. So any employee may file a work comp claim for a COVID-19 with causation to be determined in due course. That we know, but this 1159 creates a new presumption of compensability as a work comp claim, if you will, for two classes of employees. Okay. One class are first responders and healthcare workers when they test positive for COVID-19 within 14 days of a workday, which workday occurred out at a work site outside of their home. So for first responders and healthcare providers, workers, okay, that is a presumption. And once that presumption kicks in, the employer only has, this is a very quick window, 30 days to notify its 30 days to, after the claim is filed, to deny the claim and try to rebut the presumption. And in order to rebut this presumption that it's a work comp claim, the employer can only use evidence that it gathers after that 30-day window in which the employer decides whether to let it go or deny it. Only after that point in time can the employer then use evidence to deny the claim. The intent behind that is obviously to try to prevent somebody from fabricating evidence, right? And then going, I deny the claim. So once the denial's made and that 30-day period expires, you accumulate evidence. Now, what's really tricky here is that normally an employer would have 90 days to deny that claim. This is only 30 days for claims made by first responders and healthcare workers. There's a second class of employees, and this is where employers of five or more employees have an employee who tests positive within 14 days, again, of a work day, occurring at a work site, not their home, unless a caregiver, and who test positive during an outbreak at their workplace. So this is crucial because this is the other type of outbreak that we talked about, one form for 685 reporting purposes. This is as designated by local health departments. This is a work comp defined outbreak, and it's different. Okay. So an outbreak for this purpose, for presumption of workman's compensation liability purposes, within 14 days at a specific place of employment, for employers with less than 100 employees, if 4 test positive, you got an outbreak, okay, within 14 days. If you have more than 100 employees, it's 4% of your employees testing positive at a work site. Or this is the third approach to having an outbreak for purposes of work comp liability. The place of employment is ordered closed by a local health department, the State Department of Health, Cal OSHA, or a school superintendent due to the risk of infection of COVID-19. If this second class of employee comes up as a problem, then it's not 30 days to deny the claim, it's 45 days, which again still is half the time that an employer would normally have to deny the claim. And again, you can only use evidence collected after that 45-day period has elapsed. So the bill provides that evidence of measures that you've put in place to reduce the risk of COVID-19 are useful in the denial of a claim. So a question to all of you, what does that tie back into? It ties back into your COVID protection plan, your CPP that I touched on earlier. Having that document, as now required anyways, under those new Cal OSHA emergency regs, gives you an amazingly strong foothold to deny claims. Of course, all facts are going to turn on themselves, but that's a really strong piece of evidence that you're doing what you're supposed to be doing. Okay, let's go to the next slide. So continuing with this work comp presumption, notice under this provision, employers with 5 or more employees must notify their administrators, their claims administrators, within 3 business days of when they knew or should have known that an employee has tested positive. What's important here is that as an employer, we institute protocols, policies, processes, whereby our management is all on the same page and trained, so that if they get wind of someone who's infected or tested positive or whatever those triggers are, right, that information gets transmitted to the appropriate personnel who know what steps need to be taken. Because remember that if a manager or supervisor becomes aware of this information, that would be considered that the company should have known, reasonably should have known, constructive notice. And just sitting on that information and not moving it up the food chain, so to speak, is really dangerous, because obviously it's going to, you're not going to be able to deny the claim, and it's just going to create a mess in other reporting requirements. So the notice must include the date of the positive test, the address of the employee's place of employment during the 14-day period that preceded the test, and the highest number of employees who worked at the employee's place of employment in the 45 days preceding the last day the employee worked at each location. I think what's important also to remember here is that this kind of a notification issue should trigger at any employer requirements to potentially report now to third parties under AB 685, as well as potentially to notify local health departments of a COVID breakout, right? So we don't want to view these things too much in a vacuum. Okay, let's go to the next slide. So we're moving on. We're a little bit away from COVID. We're talking about AB 5. So for those of you that are aware, and I'm sure most of us are, AB 5 was that landmark legislation in California that codified the ABC test that essentially made everybody an employee and very few people be independent contractors. That law has met with unbelievable pushback from just about every sector of the economy. And as a result, even within the law itself, there was a dizzying array of exceptions, and now there are more. So there's been amendments and so forth. It's been modified. It still applies. Do not think that AB 5 does not apply. It's just that we've kind of honed some of the exceptions and modified them. And just to refresh your memories, the ABC test is as follows. A, the worker is free from the control and direction of the hirer in connection with the performance of work. B, the worker performs work that is outside the usual course of the hiring entity's scope of business. And lastly, C, the worker is customarily engaged in an independently established trade, occupation, or business, and so forth. That is the ABC test. It's so vague and broad that you can see why most people became employees and not independent contractors. Prior to that, we used to use the more lenient and broad Borello test, which came from the Borello case. And that has a myriad of indicia or elements that we could analyze and plug someone in as an independent contractor, okay? Let's move on to the next slide. So the first thing I want to say is, look, be very cognizant of AB5 and its progeny here, because if we misclassify people, the amount of damages can be astronomical. Everything from failure to pay our taxes, potential work comp liability for not accurately reflecting our employee count, obviously civil damages to that individual for failing to provide wage and hour benefits. It's a real mess. So that's why, obviously the correct classification, independent contractor versus employee, is of absolute vital importance. So under this amendment, there's some new exemptions. So first of all, there's the B2B exemption, which already existed, but now is broader and applies, if this applies to you, in public agency or when a quasi-public corporation retains an independent contractor, now applies to them. Single engagement business-to-business exemption. So this is a new one. And this basically says that, one, a standalone non-reoccurring event in a single location, when you enter into an arrangement with someone like that, so for one standalone non-reoccurring event, or here's a curious thing, it can be a series of events, but those series of events have to occur involving that one person only on one time during the week. Now it doesn't have to happen all in 1 week, but you can't be engaging them more than one time per week, although they can be doing a series of events during that week. And there's some other sub issues. So the worker has to have full control over what they're doing. They have to negotiate their rates. They have to be working under a written contract. They have to use their own tools and materials. Okay, and they have to have a separate work location, a business address from the hiring entity. So that is part of this single engagement business-to-business exception. It is just that one is when you hire someone to do one thing once, they're gone. Another is they do a series of things once a week and no more than that. Another exception is in the entertainment industry. This is pretty straight ahead. You can see what it is. I really don't want to read it off because I think it's self-explanatory. And enough said, if you're in that industry, just take a look at this. All right, let's move on to the next slide. A few more exemptions. One is for referral agencies. Okay. Interestingly, on the referral agency issue in general, the person being referred by the agency for work at this hiring entity, in order for them to fall under the referral agency exemption, so this is probably the most important feature, is that they have to negotiate their own rate, not the agency. They don't do it for them. They negotiate it themselves. It's almost like the agency just finds them an opportunity, but they negotiate the rate, okay? So what they've done under this expansion is they've added things like, consulting, youth sport coaching, caddying, wedding. You see the elements there that have been added. Professionals services, that exemption has been expanded to include these still photographers, photojournalists, freelance, and so forth. And cartoonists who the previous exemption only allowed a maximum of 35 submissions of work per year. Now they can submit more. I think kind of important here, the DA can issue injunctions against an employer for misclassification. And that's a change because it's expanded. It used to only be the Attorney General and the city attorney. So now the DA can get in on the act. All right, let's go to the next slide. Prop 22. I don't want to spend too much time on this, by the way. That's my cheering gallery right there. So they're really interested in Prop 22. All right, so Proposition 22, all of us are aware of it. It was on the ballot. This is very limited, okay? Prop 22, which was passed, only applies to app-based drivers. And it provides that the definition of an app-based driver, it's someone who provides delivery services on an on-demand basis through a business's online enabled application or platform. Apologize for the noise, folks. They use a personal vehicle to provide prearranged transportation for compensation via that online application or platform. Interestingly, 22 includes these required labor policies. I guess this is sort of the compromise. So minimum compensation, health insurance subsidies, medical costs for on-the-job injuries, and so forth. Again, if this applies to you, take a look. It's pretty straight ahead, but I want to keep moving to get to some other information. Let's go to the next slide. All right, this is a really important issue, and it's the expansion of the California Family Rights Act, CFRA. Big deal, because now this law, which previously only applied to employers of 50 or more employees, this applies basically to everyone unless you have fewer than 5. So anyone with 5 or more employees is now subject to CFRA, okay? And because of this change, what was eliminated basically is the employee count and 75-mile radius requirement that used to be a part of the law. Those are gone. So essentially now that, because we're dealing with such a small number of potentially employees, 5, that is no longer an issue. So this is interesting because you could potentially have 2 employees in California, 3 outside of California, and now you're a 5-employee company, albeit more than half of them are based outside of the state. Are you hence subject to this law? Well, we don't know. Sorry, I'm going to keep you posted because we really don't know. So that is an issue. It hasn't been clarified, but safe to say now, CFRA is enormous in its application. What are some really other important changes? The law provides covered employees with 12 weeks of unpaid leave for bonding with a new child, right? Birth, adopt. Okay. This is important because part of the change is that if 2 spouses work for one employer, we used to only allow a total of 12 weeks for the 2 of them. Now each one is entitled to 12 weeks. That's 24 total. So that's a pretty significant change, okay? Another major feature is that the new CFRA, when it talks about caring for themselves or a family member with a serious health condition, family member includes the usual child and so forth, but it also includes parent, grandparent, sibling, right? Spouse, that's always been there, or domestic partner. These are not all included within the other big law that sits in this space, the federal leave law known as FMLA, FMLA. So for now, FMLA still only applies to employers with 50 or more, not if you're under 50. But if you're a California employer and both of those apply, CFRA and FMLA, now we're in a situation where if the person is caring for a family member that is not enumerated under FMLA, that's certainly going to count against their CFRA time, but it's not going to count against their FMLA time. And if they then have a personal serious health condition, for example, they are now going to be entitled to 12 more weeks. So that's, instead of normally running them simultaneously, right, they are now going to be running after the other. So they could have potentially 24 weeks of unpaid leave for an employer who's subject to both. That is a big change within CFRA. Really important here is that employers
Hey, Michael, you're muted.
Am I muted?
Now you're good. Go ahead.
All right. I didn't want to hear what you guys don't want to know what I just said anyways. All right. So it must have looked like one of those, old Bruce Lee movies. All right, so here we go. Let's move on because continuing with moving on to the next slide. Sorry. No rehire provisions. So this is a new law. Previously, this section 1002.5 enacted last year prevented settlement agreements from including no rehire provisions with one exception, if there was a good faith finding of sexual harassment. Well, this new law on AB 2143 changes that. And what it's telling employers is that, okay, if you want to use that exception that the person committed an act of sexual harassment or assault, you have to be able to demonstrate that you documented that before they filed the claim, not after. So you got to have really good training of your staff, sexual harassment training. You got to have all your ducks in a row to make sure you can access this exception. The same thing for not rehiring someone you settled with because of potentially a criminal act. You have to demonstrate that you investigated and took all the proper steps before that situation arose. And so again, and the no rehire, lastly, the no rehire provision does not apply if any claim by an employee in question was filed in bad faith. All right, next slide. This one, I'm not going to spend any time on. I'm sure we can give you the PowerPoint if you want to look at it. This is diversity for boards of directors. And I'm not saying it's unimportant, but we have a limited amount of time and it's a very self-explanatory slide. It literally tells you what that composition of the board has to be, when it has to be done, how many people have to be represented. So let's move on to the next slide. Okay, DLSE complaints and whistleblowers. Labor Code 98.7 has been revised to increase the time from 6 to 12 months that somebody has to file a retaliation claim for as a whistleblower. Okay, and now it allows for significant penalties starting at $10,000 per violation if somebody was retaliated against for blowing the whistle, so to speak. And it permits attorney's fees. And I always preach how attorney's fees are potentially enormous. So the DLSE, the Department of Labor Standard Enforcement, the labor commissioner, is the one who's going to investigate these charges for retaliation against. What are whistleblower issues? We're looking at basically someone who discloses a violation of state or federal law to their employer. If they disclose a violation or non-compliance with local laws or rules or regs to an agency, if they believe that something is inappropriate, even if they're wrong, and they disclose that to an employer, or if even one of their family members on their behalf brings this to your attention as an employer. If they testify or provide a statement to an agency about something they believe is wrong going on in an employment situation, all of these are bases for whistleblowing. If they're being asked to participate in something they believe is illegal, okay, or against public policy, and they refuse and they're retaliated against, again, and retaliation, ladies and gentlemen, can be very subtle, right? It doesn't have to mean termination. So it can be demotion, treatment, all kinds of things. Also really important is that the DLSE can get an injunction against an employer like that, just by basically showing that they just reasonably think a violation is going on. They really have to show very little in the way of getting an injunction. All right, moving on to the next slide. We're almost done. Got two more here. This is, again, not going to affect a lot of people, but just to be known, we have expanded in the state successor liability for companies that are purchased. So Labor Code 203 provides that a successor to a judgment debtor will be liable for any wage damages and penalties owed by the judgment debtor's former workforce pursuant to a final judgment. And the successor entity that would be liable for such a situation when they buy a company would fall into a new company, basically, that uses substantially the same facilities or the same workforce and offers the same services as the predecessor, has substantially the same owners or managers that control the labor relations, employs management who directly control the wages and hours of the prior workforce, and operates in the same industry as the judgment debtor did, and has an owner, partner, officer, director who, or immediate family member owner from the prior judgment debtor. So pretty straight ahead stuff. Statements of information that were required to file corporate every year now include information on successor liability. All right, lastly, next slide. Drum roll. New pay data reporting. Employers with more than 100 employees who are required to file an EEO1, which deals with race, ethnicity, and gender within those 10 federally identified job categories. These employers must collect and submit compensation data now to the Department of Fair Employment and Housing on the following. The same as the EEO1, and so the same information, and the number of employees by race, ethnicity, gender, whose annual earnings fall within each of the pay bands used by the U.S. Bureau of Labor Statistics, and so forth. You can read through this gobbledygook. You can see what the reporting requires. I'm not going to read it. It's pretty straight ahead. DFEH is going to create forms for this, and non-compliance can result in the DFEH recovering costs if they have to order an employer to do this, and the reports must be submitted by the end of March of this year. Okay, I know it was a lot. I know I covered some and didn't cover a lot of others, but there you go. Thank you very much, and I'm sure, I presume there's some questions.
Hold on. Hi there. Can you hear me, Michael?
Yeah. Hey, Matt.
Okay. Yeah. There's a few questions. I replied to a few people already, but okay. So some really simple things. But everybody, we're going to send out. A lot of people have asked. We're going to send out your
the presentation
for your presentation to everybody. So we'll include that to everybody that's on, so they can have all the slides. A few questions. If an employee. What if an employee is asymptomatic and doesn't know and may not know for a while? You know, what happens with the 48-hour rule? Does this go down the drain?
Yeah, it's a tough one. I had a feeling that was going to come up because a lot of people are asymptomatic. So I don't know. I mean, a lot of people that are asymptomatic, first of all, never get diagnosed, right? I mean, right. So we never know. I guess it's a good question. I would presume, look, if someone who's asymptomatic, I would use the date they're tested positive. I mean, I don't think there's really any other date to go by, or, you know, and use that as your frame of reference, and then look at, you know, what the reporting, you know, what periods you have to analyze going back in time and so forth. It's a tough one because you're right. Yeah. Asymptomatics, it's a reality.
Another question. Do you feel when a company reopens, it's best to have a certified COVID commander come in and make certain everything is accurate and or get the office in order as that it goes way beyond Cal OSHA and posters are up on the wall?
Oh, I love that. A COVID commander, man. I'm having some wild images here. Riding in on his horse. But so I would say, look, I definitely think it's always better to go further, right? And what we're talking about here is safety. So if by a COVID commander, we're talking about a safety expert, I think it's a great idea. You know, there are very economical ways of doing this, having someone come in. You know, we have a partner enterprise, Thrive in Safety. They do it virtually just to to give you guys a heads up, so they have, and I'm sure, so they use Zoom to go around your workplace, and, you hold up your laptop and they take pictures and give you feedback. And it's dirt cheap, and you may find other safety consultants that are willing to do the same. That would be for a small, more of a white collar environment. If it's a more of a blue collar, potentially hazardous work environment, have someone come in and go do a once over, make sure the PPE policies are appropriate, that the company's got the right social distancing, because there are really subtle things that I've learned, just for example, from dealing with safety, like don't have vending machines anymore. Don't have, areas where you get congregating people or touching things. So how do you handle packages and deliveries? Yeah. So I think it's a great idea. It's also good for a COVID commander to check, any medical screening that you plan on doing to employees, because we have to be very careful of potentially trampling on people's privacy rights or pre-existing disabilities, not discriminating, lots of stuff.
Okay, great. Besides being part of onboarding, does this need to be added to the employee company handbook?
Are we talking, what specifically?
I guess we're
talking, sorry, it was about the CIFRA. Thank you.
Absolutely. CIFRA. That's why I said, and I know I might have said it quickly, so I'll reiterate. Large employers, those 50 or more who've had a traditional CIFRA policy, you need it reviewed and modified. Those who fell below the 50 threshold that are now part of CIFRA's family, 5 or more, you need to have that policy drafted. And the CIFRA policy is very complex and should be done by someone who's an expert.
Okay. I think if anybody has any other questions, I think that is it. I think one's coming in right now. I just want to ask you before we get off the phone. We're off our Zoom meeting. Okay. Lisa was just on. She asked a question, but she's asking the number of the company that you're referencing. I don't. Yeah, Lisa, you want to jump?
The company that would come in or do virtually.
Trivent. That's Trivent. And
thank you, Scott. Thank you, Michael.
Lisa. Thank you. Go ahead, Michael.
Oh, yeah. So it's Trivent Safety. If you go to our website, there we have a safety page, and you can find them there. And they're excellent. They're professional, and we've worked with them for a while. And they have just a really good structure in place because they know small employers need this, and they don't want to break the bank. So
I know another question is coming in, but before we get off, I just want to everybody who's on the call, Michael, we really appreciate you. You're amazing. You are a wealth of knowledge. I mean, we're so happy to be partners with you, and you make us, you're just a great partner, makes us look good, and we've been helping out our clients for years, and we just really, really appreciate you. And with that, if anybody has any questions, if you have any questions for Michael, for us, I love the opportunity to talk to you. Reach out to us. You can email us. You can email us at marketing@corpstrat.com, or just give us a call at 818-377-7260. We'll connect you with Michael if it's needed, but love to talk to you. And I think that with that, we'll end the call, and just really appreciate you, Michael.
Hey, my pleasure, Scott. You guys are great. Thanks, everybody.
Okay, take care. Bye, everybody.